want to have a little quick side digression about the potential effect of non-trademark law on a lot of trademark-related issues. And I said in the initial lecture that rather than thinking of trademark as a form of intellectual property, I really think it's better to think of it as a form of consumer information regulation. And just as trademark law affects the way sellers and others are able to use particular terms in the sale of goods and services, so too may regulation by the state. And that includes the definition of meaning of certain kinds of generic terms. So, for example, under the Food, Drug, and Cosmetic Act, only catfish from the United States can be sold as catfish. And why? Not because of marketplace realities or the way consumers have come to use the terms, but rather because a statute specifically regulates what can be sold as catfish. And of course, there's any number of examples of this. There are requirements for what kinds of whiskey can be sold as bourbon, and in turn straight bourbon, and rye, and corn whiskey, and wheat whiskey, and any number of alcoholic beverages, any number of food products, et cetera, et cetera, et cetera. And the stakes in these kinds of regulatory decisions can be rather high. And some of you may have followed in recent months and years, there have been some fights at the state level about whether or not certain kinds of meat alternatives can be sold as meat, even though there's this sufficient qualifiers. Those who are selling the products want to advertise that there is in fact no animal flesh in their products, but certain aspects of the meat industry are concerned that that's going to be bad for business, and they want to, this kind of competition is bad for business, and they want to bring actions or get laws that prevent sellers of vegetarian or vegan products from using the terminology of meat. And so, there have been laws or efforts at the state level to limit the ability of people to brand their vegetarian or vegan product as fake meat. Likewise with milk, things like soy milk, almond milk, oat milk, those kinds of things. The dairy industry has tried to get the FDA to issue rules that says you can't use the term milk when you are describing the products in question. Another interesting piece of food-related law that gets a little bit closer to trademarks specifically are regulations concerning so-called geographical indications. These are terms that indicate origin in a particular part of the world and often made in a particular way. And these geographical indications, the requirements thereof, are regulated by various governments, and they are a frequent topic of treaty negotiation. And they're something that traditionally have been a lot more important to producers in Europe than they have been in the United States, or at least the United States has generally been reluctant to embrace GIs to the same level that the European Union has. And so within the US, usually the kind of protection you get under a geographical indication is usually under a certification mark. The idea that you're certifying that a product has certain attributes, and it's not necessarily the product of a particular source. Multiple sources may provide this, but they're certified to have a particular quality. And so you see things like, Idaho potatoes being an example of a certification mark, or Parmigiano Reggiano cheese, which in the rest of the world is known as Parmesan cheese. In the United States, Parmesan is a generic term, and so those who want the quote-unquote real thing, the thing that is protected by the GI in other parts of the world, the certification mark Parmigiano Reggiano does the work. And GIs present an interesting question of potential conflict between consumer classes. Because on the one hand, some consumers may be interested in Parmesan cheese as a particular cheese of a particular quality. And the fact that anyone can use the term Parmesan cheese functions almost as a form of fraud. That consumers are expecting the quality associated with cheese made from the Parma region of Italy, made under the particular regulations of the GI, and that's what they expect. And when you get that, powdery sawdust stuff out of the craft tube, there's almost a form of fraud going on. On the other hand, maybe when consumers see the word Parmesan, they are using that to identify a particular style of cheese. And within those who prefer that kind of style, there are a range of preferences. Not everyone can afford the expensive stuff from Italy. Not everyone likes the expensive stuff from Italy, while still liking or having some affection for a cheese that's evocative of that style in one way or another, and they find the cheap craft version to be an appealing alternative. And I'm not sure that in the abstract there's necessarily a reason to favor one class of consumers over the other, especially given that trademark law does not protect generic terms, and maybe as an empirical matter, it just is the case that in the United States, the consuming public uses the word Parmesan as a generic term. I'm not making arguments one way or another about what they do as an empirical matter, but that could just be the case. And I don't know that abstract principles necessarily answer the question of which class of consumers ought to be favored. Those who want to use it to identify the quote-unquote real thing, or those who want to use the term generically, or those who get a benefit in the marketplace from sellers being able to market to them under the generic term. And then we have this interesting side question, though, about whether the empirics are really what matter here. And, we could also make the potential claim that maybe what's going on for those consumers who really want the real thing or who would really appreciate the real thing, that maybe that's a manufactured preference. And that, maybe those who really prefer, authentic champagne or authentic Parmesan, that part of what's going on is just the belief that they are getting something better, that there is sort of this aura around the brand, and that maybe if you actually had a blind taste test, that preference would actually go away. Then we might wonder about whether or not GIs ought to be protected anyway, right? Do we want to promote so-called traditional techniques or the cultures that created certain kinds of products in the first place? Do we believe in other kinds of hard to ascertain benefits? So, for example, the idea that things made in the traditional way are just better, even if we don't necessarily have a way to measure that. Or, maybe these are just another form of status goods, and debates about whether or not to protect GIs are very similar to debates that we'll discuss in later lectures about whether or not status goods ought to be protected, even in the absence of a likelihood of confusion. So in all these cases, we have this question about what it means to protect or inform consumers. How do we choose between consumers who use champagne to identify a style of wine and those who use it to indicate a region? And then the question I adverted to before as to whether or not we should view this as an empirical question about which consuming class benefits more, or again, if there are other interests that we want to vindicate by protecting the GI, notwithstanding perhaps the argument that consumers might benefit on the whole, hypothetically, by treating the term generically. And I'll leave it there. Thanks very much.